Hi, everyone. My name is Rebecca Ho, and I am president of the Berkeley Law Chapter of the Federalist Society. Tonight, we are going to discuss the importance of amicus briefs in IP law. But before we do that, I want to give a little bit of information about the Federalist Society's practice groups. The Federalist Society's 15 practice groups are organized by substantive areas of law. Each practice group is led by a chairman and executive committee comprised of top lawyers from across the country. They meet each month to organize in-person events, webinars, publications, and the panels for the Federalist Society's flagship event, the National Lawyers Convention. You can learn more about the practice groups at fedsoc.org/practice groups. Tonight we have with us Rob Rando of the Federalist Society's Intellectual Property Practice Group. Rob is a partner at Greenspoon Marder, where he focuses on patent and other IP infringement dispute matters. He received his Bachelor of Science with academic honors in mathematics and computer science from Hofstra University. Before attending law school, he was a systems analysis engineer at Sperry Corporation, now a part of Lockheed Martin. There, Rob helped design, develop, implement, and analyze computer software that could use advanced mathematics as part of nuclear submarine navigation and weapon systems. Rob then graduated with honors from St. John's University School of Law, where he was the executive publications editor of the St. John's Law Review. Rob began his career at Skadden and then founded and led his own firm for nearly 25 years. He is a fellow of the Academy of Court-Appointed Masters and has served by judicial appointment as a special master in numerous cases involving complex patent law issues. Rob has extensive civil litigation and appellate court experience, including having served as counsel of record or co-counsel on numerous amicus brief filings before the U.S. Supreme Court and Federal Circuit on various IP, constitutional, and administrative law issues. Audience members, if you have any questions for Rob throughout the program, please use the Q&A feature to submit those questions. And with that, I will turn it over to you, Rob.
Thank you very much, Rebecca. Good evening. And I would also like to thank the Federalist Society and those of you in attendance tonight for the opportunity to discuss amicus practice and intellectual property in this webinar. Amici speak the importance of amicus briefs in IP law. I will begin my discussion with a basic primer on IP law. I'll then provide a general discussion about amicus practice, and then I'll follow that up with a sampling of amicus briefs that I've filed in cases at the Supreme Court as counsel of record or co-counsel, illustrating the importance of amicus briefs in IP law. And then we can end with a Q&A session. So a brief primer on IP law. What is IP law? IP law covers patents, copyrights, trademarks, trade secrets, and likeness publicity rights. Patents. Patents protect a broad range of inventions and designs, including processes, machines, articles of manufacture, compositions of matter, new, original, and ornamental designs for articles of manufacture. Patents come in utility patents, right, which is the right to exclude others from use, manufacture, sale, or import of useful, novel, and non-obvious inventions for 20 years from date of application filed at the USPTO. There are also design patents, which is the right to exclude others from use, manufacture, sale, or import of ornamental, novel, and non-obvious articles of manufacture for 15 years after issuance of design patents. Next, we have copyrights. Copyrights protect works of authorship, such as writings, music, works of art, and performing arts that have been tangibly expressed. They grant the creator of a literary, artistic, musical, or other creative work the sole right to publish and sell that work. The term is life of author plus 70 years after the death of the author. And the key to copyrights is originality. It must originate from a particular author and not from another. Next is trademarks. Trademarks protect words, names, symbols, sounds, or colors that distinguish goods and services. They can cover any word, name, symbol, or design, or any combination thereof used in commerce to identify and distinguish the goods or services of one user from another and to indicate the source of the goods or services. Rights accrue from the date of first use, and duration is for as long as it is used. Think of it in terms of branding. Next, we have trade secrets. Trade secrets protect information, for example, invention ideas or compilations of data that companies keep secret to give them a competitive advantage. It can be any useful formula, plan, pattern, process, program, tool, technique, mechanism, compound, or device that is not generally known or readily ascertainable by the public. Whatever type of information is represented by a trade secret, a business must take reasonable steps to safeguard it from disclosure. Next, we have likeness and publicity rights. The right of publicity can be defined as the right to control the commercial use of one's identity. Likeness and publicity rights are typically referred to as name, image, and likeness, and vary by state. It is the property interest inherent in an individual's name, voice, signature, photograph, image, likeness, distinctive appearance, gestures, or mannerisms. You can keep this in mind with respect to what is in developing in the area of artificial intelligence. While likeness publicity rights disputes usually involve celebrities, the majority views that the rights extend to every individual, not to those who are just those who are famous. Now, there are IP-related areas of law. The IP crossover areas of law include new technologies law, novel issues of how IP protections and enforcement are handled for AI, blockchain, cyberspace, and the metaverse. Social media law, privacy, copyright, trademarks, defamation, advertising, contracts, First Amendment, and criminal. Entertainment law, all IP issues, contracts, criminal, First Amendment. Contract law, licensing, shrink wrap, web wrap, software EULA, corporate law, M&A due diligence for IP ownership, valuations, contingent liabilities, and other obligations, for example, license agreements. And bankruptcy law, similar to corporate law, and specific rules for license agreements. And then the criminal law, just ask any entertainment lawyer representing a celebrity, athlete, team, or media company. And international law, import, export, the Court of International Trade, tariffs, and the International Trade Commission, exclusion orders, Hague Convention litigation issues, and harmonization. Now, for a general discussion on amicus practice. Throughout the United States and in other countries, there's an increasing recognition and appreciation of the purpose and value of amicus curiae practice and amicus briefs, and their vital role as adjunct to adjudicatory, legislative, and rulemaking processes. By addressing issues that party litigants, legislators, and rulemakers themselves may not have sufficiently developed, Amici can supply helpful insights in shaping decisions, statutes, and rules, which may have far-reaching implications, or in dissuading tribunals from reaching incorrect decisions that could have unforeseen negative consequences that may otherwise be overlooked. The participation by non-litigants as amici curiae in aid of decision-making is by no means a recent phenomenon. In the history of this country, the filing of amicus briefs has been enabled and governed in large part, not by statute, but rather by procedural rules born of political, socioeconomic, and judicial policies and practicalities. The legitimacy of amicus curiae practice has been recognized as being grounded in the First Amendment rights of freedom of speech or the right of the people to peaceably assemble and to petition the government for redress of grievances. A recent surge in the proliferation and citation and increased media notoriety being given to amicus briefs and other submissions of private organizations, individuals, and governmental entities, acting alone or in consortia, in a broad spectrum of cases, and other matters affecting the public interest as well as the interests and concerns of the parties, that is, the principal actors, and non-party bystanders, testifies to the importance and will likely continue unabated. Tribunals that receive amicus briefs have shown a growing willingness to consider those that add value to the decision-making and opinion-writing processes amid rules and policies governing their preparation and content, and that are submitted by Amici who have certified their interest in and relevance of the briefs to the issues in the case, and wherein counsel of record for Amici are authorized to appear. The acceptance and consideration of and the weight given to amicus submissions are generally subject to the discretion of the governmental body that received them. Regarding amicus briefs, they are usually docketed for consideration by the tribunal only pursuant to procedural rules of the tribunal, or with the party's express or implicit consent, or upon motion granted for leave to file, or when submitted by the government, or upon the invitation of the tribunal or by appointment. Such briefs can be helpful and often persuasive in promoting case outcomes that may influence future behavior in beneficial ways. A purposeful, credible, well-written amicus brief is optimally useful and more likely to be read by judicial law clerks and heeded by the judges to whom they report when it reveals or illuminates jurisprudential consequences or real-world impact of the tribunal's ultimate decision that could significantly affect the broader community of people, institutions, and business entities. When it from a recognized and respected source, when it does not seek to extend or evade the page or word count limit imposed on a supporting party's merit brief, or to provide what is in effect an additional brief on behalf of that party. When it's not a, quote, Me Too brief, merely rehashing arguments, insights, facts, or data in briefs of the supporting party or of other amici who have already tilled the field with a sharp enough plow. Instead, a good amicus brief adds value to the decision-making process by shedding new light on the controversy with arguments based on relevant, new, or non-obvious points of law, or matters of fact beyond the decision-maker's familiarity or expertise. Such arguments are grounded on credible assertions of perspectives, historical context, or other facets of the issues presented by the parties, that expresses consensus views of classes or coalitions of interested entities of all stripes, speaking as one voice in a single brief, that presents in what is known as a Brandeis brief, relevant new information in the form of verifiable data, studies, or other empirical findings, which are germane to the issues or questions presented and that are helpful to the decision maker. A Brandeis brief is a colloquialism named after Louis D. Brandeis. In the early 1900s, while in private practice prior to becoming a U.S. Supreme Court justice and a staunch proponent of amicus practice, he filed an innovative amicus brief in Muller versus Oregon in 1908, in which he advocated persuasively in support of legislation setting a 10-hour maximum workday for women, based in part on publicly available socioeconomic data. One of the most significant cases in which Brandeis brief played a pivotal role in the judicial decision-making, having a profound effect on the development of public constitutional and judicial policies, can be found in Brown versus Board of Ed. There, the Supreme Court took judicial notice of published evidence submitted by a number of amici curiae, showing that the separate but equal doctrine in the field of public school education deprived children in racial minorities of equal education opportunities in violation of the 14th Amendment. And an interesting recent example of a persuasive Brandeis brief is one which was submitted in the Supreme Court same-sex marriage discrimination case of Masterpiece Cake Shop versus Colorado Civil Rights Commission by a consortium of cake artists in support of neither party. The brief featured color photographs of custom-made cakes created for various occasions, imaginatively decorated as unbiased articles of artistic expression. These foregoing factors rarely go unnoticed, unacknowledged, or unappreciated by tribunals, litigants, and journalists. And if the tribunal has respect for the amicus and its counsel, then such briefs are unquestionably proper and useful, and indeed, in some cases, expected. My own experience when speaking with judges and justices is that they do appreciate amicus filings. As a result, good amicus briefs can be extraordinarily valuable, but not only the tribunals, but also the parties and other entities whose position and interest they support, and indeed to the public as well. They are prized because of their contribution to the justice of the decision-making process. And according to a September 21, 2016 issue of the National Law Journal Supreme Court brief, in the preceding year, more than 860 amicus briefs, a 20% increase over the previous term, was submitted from disparate sources in over 90% of the SCOTUS cases. Those briefs that satisfied the foregoing criteria often captured the court's attention, and of which about 8% were referred to during oral argument or cited in reported decisions. And in another study, H.W. Perry, in his book on the court's decision-making process titled Deciding to Decide, Agenda Setting in the United States Supreme Court, presented a statistical analysis of random sample of certiorari petitions in the US Supreme Court, showing that an amicus brief filed on behalf of a petitioner increased the acceptance rate from 8.5% to 37.1%. Now that I've explained IP law and amicus practice, I will now provide some sample amicus briefs I've filed in cases at the Supreme Court as counsel of record or co-counsel, and discuss the importance of these briefs. The first case that I'd like to point out is a very recent case, Jack Daniels Properties Inc. versus VIP Products LLC, docket number 22-148. Oral argument is recently conducted on March 22nd, 2023. The issues in the case are whether humorous use of another's trademark as one's own on a commercial product is subject to the Lanham Act's traditional likelihood of confusion analysis, or instead receives heightened First Amendment protection from trademark infringement claims. The second issue, or question presented, is whether humorous use of another's mark as one's own on a commercial product is non-commercial under 15 U.S.C. section 1125 lower C 3 upper C, thus barring as a matter of law a claim of dilution by tarnishment under the Trademark Dilution Revision Act. And the facts of this case is a trademark infringement case involving the sale of a dog toy resembling a Jack Daniels bottle. The Jack Daniels bottles have the words Old No. 7 brand and Tennessee Sour Mash whiskey. The dog toy proclaims, quote, the old No. 2 on your Tennessee carpet, close quote. The original bottle notes it is 40% alcohol by volume. The dog toy features a dog's face, and it says 43% poo by volume and 100% smelly. The important IP issue for the amicus following is the intersection of the First Amendment free speech and protection against trademark infringement. Where to draw the line and between which to draw the line between permissible parody and infringement. In the amicus filing, we argued that the First Amendment Rogers versus Grimaldi test for the tension between free speech and trademark protection should not replace the likelihood of confusion analysis for the Lanham Act infringement claims involving ordinary products. Excuse me. And argued for parody to be found infringing, confusion must be likely. In this case, one would question whether a Jack Daniels would support that there would be confusion for something that parodies their bottle. An assessment more robust than Rogers' test is required to assess infringement claims for products, and that the Lanham Act's dilution exclusion for non-commercial use requires more than just a humorous message. Excuse me. The next case sample is Amgen Inc. versus Sanofi, docket number 21-757, and the oral argument was conducted March 27th, 2023. The issue in Amgen is whether enablement is governed by the statutory requirement that the specification of the patent teach those skilled in the art to make and use the claimed invention, or whether it must Instead, enable those skilled in the art to reach the full scope of claimed embodiments without undue experimentation. That is, to cumulatively identify and make all or nearly all embodiments of the invention without substantial time and effort. Facts of this case is a patent infringement case involving two pharmaceutical companies. The accused infringer claimed that the patent in suit was invalid because it failed to meet the statutory requirement of enabling a person of ordinary skill in the art to practice or make and use the invention. Essentially, the argument is that the patentee was overclaiming by failing to identify all species of its genus claim. Excuse me. The important IP issue for this amicus filing is that the plain language of the statutory enablement requirement does not include the quote, reach the full scope of claimed embodiments, close quote, without undue experimentation as required by the Federal Circuit. The innovation incentive built into the US Constitution, providing a quid pro quo for disclosing your invention, may be at risk of inventors keeping their inventions as trade secrets. Amicus filing. There were over 30 amicus briefs filed in the case, roughly equally arguing support for either of the two different parties. The amicus filing that I co-authored argued for a unique solution, applying the full scope test for enablement validity at the infringement stage and not the patent prosecution, that is the application stage, in the USPTO. The next case that I'd like to point out is In Re Grand Jury, docket number 21-1397. Oral argument January 9, 2023. Opinion January 23, 2023, and I'll explain what that quick turnaround was about. Excuse me. The issue in this case was whether a communication involving both legal and non-legal advice is protected by attorney-client privilege when obtaining or providing legal advice was one of the significant purposes behind the communication. Excuse me. The facts are pretty straightforward. This is a case involving a mix of legal and non-legal advice in a tax law matter. The important IP issue for amicus filing, although this is not an IP case, the underlying substantive case was tax law. IP lawyers often give advice involving legal and non-legal communications due to the understanding and advice that IP lawyers will give with respect to the business implications of their creations and inventions. In the amicus filing, we argued the DC Circuit's significant purpose test provides clarity and predictability that the alternative predominant purpose test does not. Unfortunately, and this gets back to the quick turnaround by the Supreme Court, the SCOTUS dismissed as improvidently granted in a per curiam opinion on January 23rd, 2023. I say unfortunately because the area of law concerning attorney-client privilege needs to be very clear for robust communication between client and attorney. Now for the next case, Andy Warhol Foundation for the Visual Arts, Inc. versus Goldsmith, docket number 21-869, oral argument October 12th, 2022. The issue in this case is whether a work of art is transformative when it conveys a different meaning or message from its source material, as the Supreme Court, U.S. Court of Appeals from the Ninth Circuit, and other courts of appeals have held, or whether a court is forbidden from considering the meaning of the accused's work, where it recognizably derives from the source material, as the U.S. Court of Appeals for the Second Circuit has held. The facts in this case, the case involved a copyright infringement of a photograph of the music entertainment star Prince. The photographer Goldsmith sued the foundation, claiming that Warhol had infringed her copyright and that the foundation owes her potentially millions of dollars in unpaid licensing fees and royalties. The foundation countered that Warhol not only copyrighted his iconic Prince series, but that his treatment was, in legal terms, transformative, because his artistic rendering is very very different from Goldsmith's original photo. The foundation asserted that in Warhol's version, not only did Warhol crop the image to remove Prince's torso, but he resized the image, altered the angle of Prince's face, changed the tones, lighting, and detail, in addition to adding layers of bright and unnatural colors, conspicuous hand-drawn outlines, and line screens and stark back shading that exaggerated Prince's features. The important IP issue for Amicus filing is clarity of the transformative copyright infringement cases. In the Amicus filing, we argued that the court should clarify that its transformative test employs a totality of the circumstances approach, and that the court should delineate the factors for inclusion under a totality of the circumstances transformativeness test, and that the purpose and character inquiry should also consider whether the use of the copyrighted work was necessary or could have been accomplished by using non-protectable material. The next case is Unicolors Inc. versus H&M Hennis and Moritz LP, docket number 20-915, oral argument November 8, 2021, opinion February 24, 2022. Sorry. The issue in this case is a safe harbor provision in the Copyright Act, which allows a copyright holder to enforce an otherwise valid copyright, despite having included inaccurate information in his or her copyright registration application, so long as he or she did not have knowledge that the information was inaccurate. 17 U.S.C. Section 411, sub B. The question presented is whether the safe harbor provision excuses only good faith mistakes of fact, not law. The facts of this case: Unicolor brought an action under the Copyright Act against H&M for infringement of fabric designs that Unicolors had registered with the Copyright Office. In response, H&M moved to dismiss the claim, contending that Unicolors could not maintain an infringement action because Unicolors' copyright registration application contained inaccurate information. The district court denied the motion to dismiss. Ninth Circuit reversed, holding that the safe harbor provision excuses only good faith mistakes of fact, not law. So the important IP issue for Amicus filing is the clarity of the safe harbor provision of the copyright law in copyright infringement cases. And in our Amicus, we argued for affirmance, and that Section 411 sub B does not require a separate showing of intent to defraud, and that intent is implicit where Section 411 sub B is satisfied, and that Section 411 sub B contains sufficient safeguards against abuse. In its judgment, the court reversed, holding that the safe harbor provision applies to mistakes of both law and fact. Next case is Minerva Surgical Inc. versus Hologic Inc. Docket number 20-440. Oral argument April 21st, 2021. Opinion June 29th, 2021. In this case, the issue is whether a defendant in a patent infringement action who assigned the patent or is in privity with an assigner of the patent may have a defense of invalidity heard on the merits. The facts in this case: Cassava Truckeye was listed as an inventor on 2 patents related to procedures and devices for endometrial ablation that he later assigned to the company he co-founded, Novocept. Novocept was ultimately acquired by Hologic, and the company inherited the patent's interests. Truckeye left the company and co-founded Minerva Surgical. At Minerva, he developed a new product related to endometrial ablation. Hologic filed patent infringement claims against Minerva. Minerva filed review claims for the patents with the USPTO. The office found that one patent was not patentable, and the Federal Circuit upheld the ruling. Hologic argued that Minerva could not challenge the claim's validity based on the doctrine of assignor estoppel. Both parties cross-appealed to the U.S. Court of Appeals for the Federal Circuit. The court affirmed in part and vacated in part the district court's order. The important IP issue for amicus filing is the clarity of the assignor estoppel doctrine in patent cases, which is very necessary because in order to understand what rights are being conveyed and what rights are being limited, one needs to know how the court will decide these cases in the future. In the amicus filing, the Federal Circuit's rigid application of assignor estoppel is at odds with the fact that it is an equitable doctrine that, consistent with the court's precedent, considers the specific facts to reach an equitable outcome for both assignees and assignors. The court should clarify that whether estoppel applies or not should be determined based on the specific facts of a given case as a matter of equity, with analysis as to what was assigned and what claims are ultimately asserted against the assignor. Case-by-case determination as to whether estoppel applies and to what extent preserves fair dealing for the assignee and avoids the unfairness of a bright line rule that precludes the assignor from challenging the validity of an asserted patent in cases where the issued patent claims are divorced from that which was actually assigned. Thus, the court should overturn the Federal Circuit's per se application of assignor estoppel in favor of an equitable approach. The judgment: the court, in a 5-4 opinion by Justice Kagan, vacated and remanded, holding that the well-grounded patent law doctrine of assignor estoppel applies only when the assignor's claim of invalidity contradicts explicit or implicit representation that the assignor made in assigning the patent. Justice Alito filed a dissenting opinion. Justice Barrett filed a dissenting opinion, in which Justices Thomas and Gorsuch joined. The next case is American Axle and Manufacturing versus NEPCO Holdings, docket number 20-891, oral argument. There was no oral argument since the court denied cert. The important issue for amicus filing. In this case is among the most important IP cases at the Supreme Court. Unfortunately, the court refused to weigh in and denied cert. I am most proud of this amicus brief filing, as I was asked to be counsel of record representing United States Senator Tom Tillis, retired Federal Circuit Judge Paul Michel, and former USPTO Director Dave Kapos as Amici. But most importantly, the issue in this case is of monumental concern for the vitality and stability of the U.S. patent law system. The issue is known as patent eligibility. Patent eligibility is statutorily stated under 35 U.S.C. Section 101 of the Patent Act as follows, quote, whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvements thereof, may obtain a patent therefore, subject to the conditions and requirements of this title, close quote. The Supreme Court has engrafted on the plain language of the statute exceptions from the patent eligibility requirements for laws of nature, natural phenomena, and abstract ideas, and holding that they are not patent eligible. And they created what is referred to as the Alice Mayo test, named for 2 patent eligibility cases decided by the Supreme Court. This case, American Axle, involved a mechanical device that was considered to be ineligible by the courts below as a, quote, abstract idea. As you will see from my following articulation of the arguments of Amici, this circumstance of the current law for patent eligibility, in my opinion and that of Amici, is wreaking havoc on the patent law system to the detriment of the U.S. inventor and the broader innovation communities. The arguments by Amici in the amicus filing. First, the disparate and inconsistent application of the court's jurisprudence has created an unpredictable and unstable U.S. patent system, contrary to Article 1, Section 8, Clause 8, constitutional imperative to incentivize innovation. And statements from a wide array of judges, legislators, and policy experts attest to the confused state of the law, including judges of the U.S. Court of Appeals for the Federal Circuit, members of U.S. Congress, congressional testimony, the U.S. Solicitor General, U.S. Chamber of Commerce, U.S. Patent and Trademark Office, and the National Security Commission on artificial intelligence, and that Section 101 uncertainty is impacting incentives to innovate and invest in critical technology, including healthcare, medical diagnostics and treatments, quantum computing, artificial intelligence, and machine learning, and biotech. And that rulings that wrongly curtail patent eligibility destroy innovator and investor confidence in the US patent system's ability to promote innovation and US technological leadership. And that preserving America's competitiveness in the useful arts requires clear direction that preserves patent eligibility for protection-worthy inventions, and that the stability and vitality of US patent law depends on the reasonable, consistent, and settled judicial application of a statutory framework. The proliferation of inconsistent and deeply divided holdings regarding Section 101 eligibility starkly reflect courts' unsuccessful struggles with the Alice Mayo test in real-life controversies, and that this court should ameliorate the chaos which, if allowed to continue longer, will further undermine the constitutional underpinning of the patent law to promote the progress of the useful arts. And I would like to point out that most of my amicus filings are with the New York Intellectual Property Law Association, NYIPLA. However, as in the American Axle case, I filed the amicus briefs with the Association of Amicus Counsel, which I founded with several other colleagues a few years ago. There are numerous other important IP cases in which I and many Amici have filed briefs. In the interest of time, I can identify a couple more, or we can go into questions and answers.
Thank you for those insightful remarks. I think let's move to some questions.
Sure.
Given the interest of time. So how do you view government filing an amicus brief? Should government even have a role?
Well, the Supreme Court will often invite the DOJ Civil Division, which is well equipped to weigh in, and sometimes the Supreme Court even ignores what they say. And in fact, in the American Axle case, the government, the Solicitor General's office argued that the case should be taken. And then I guess, should the government have a role? That is a better question. And I'll say this with a wink and a nod. If the government has an unbiased opinion, big if, then I would say it's okay.
Gotcha. Another question. Up until this year, anyone who wanted to file an amicus brief in a case before the US Supreme Court had to obtain consent from the litigants on both sides of the dispute, but this was actually changed so that they no longer have that consent requirement. What are your thoughts on the Supreme Court having eliminated that consent requirement?
Well, sure. So more often than not, it was routinely granted by the parties. And in the rare case where it was not, a motion to the court was usually granted. So I think it really was a recognition that it was a hoop that no one really needed to jump through any longer, if that makes sense.
Makes total sense. And then I wanted to ask one more question on the topic of amicus briefs itself, and then maybe we can switch over to a question about the practice groups. But do you approach writing an amicus brief differently for an IP issue versus a non-IP issue?
Not necessarily, except for the difference in the substantive issues. And of course, if it is a constitutional issue, et cetera, there is a different perspective. But the general thrust for filing an amicus brief is either the policy issues that are at hand, which impact a broader community beyond the parties, or a specific issue, and especially when it comes to intellectual property law, which is a specialized area and which many of the Supreme Court justices in the past and those present on the Supreme Court will tell us that are very difficult questions to decide. It really is to assist the court on very nuanced issues in IP law.
Gotcha. And switching gears to the practice groups, could you describe the work of your particular practice group?
Sure. So we focus on all things IP and all related areas of crossover laws that I discussed earlier, and even including international issues that are implicated with respect to domestic IP law.
And how can students and recent grads get involved in the practice group?
Well, certainly, students and recent grads can reach out to practice group leaders or members, and certainly send me an email. Reach out to me. I would be happy to guide any students or recent grads with respect to joining practice groups.
And I think that's a great point to end on. Normally, I would introduce next week's practice group presentation, but Rob, we are actually the last event in the PG-15 series. We are number 15 of PG-15. So thank you, everyone. So thank you,
Well,
everyone.
I hope that my finale performance did not disappoint.
No, it was great. Thank you so much.
Thank you.
And I also want
Yeah,
I also
sorry.
I also wanted to thank everyone for tuning in, and please stay tuned for more FEDSOC programming in the future. And with that, we will conclude the program.